everyone, and welcome to Uncivil Law. For today's case, we have a decision from the Sixth Circuit Court of Appeal that says there's a constitutional guarantee of literacy. The government is required to give you literacy, according to the Sixth Circuit Court of Appeals. You may remember we recently covered this topic in the form of a story that was being written in anticipation of this decision. So we covered that relatively recently, and we'll link to that. But the decision has actually been reached. The Court of Appeals says you have a right to literacy under the federal Constitution. So we're going to read this and analyze it. Let's get started with this. The Michigan Constitution provides the state legislature shall maintain and support a system of free public education and secondary schools. The Constitution also vests leadership and general supervision all over public education in a state board of education which serves as a general planning body and coordinating body for all public education. Now, if this were being decided under state law, I wouldn't be having massive problems because, as we've learned many times, the federal Constitution sets a floor, not a ceiling. And a state can also guarantee more rights than the federal government. So if a state wanted to guarantee people a right of education and so forth and so on, and we were analyzing this as a matter of state law, that would be fine. But we're analyzing this as a matter of federal law, federal guarantee. We're saying there's a federal guarantee to education. So if they said Michigan Supreme Court or Michigan State Constitution required, that'd be one thing. Well, that's not where we are. So that's, the difference between the citation and where we're ultimately going to wind up. According to the plaintiffs, education is a state-level concern and school districts are simply creatures and agents of the state. The Michigan Supreme Court has repeatedly held that education in the state is not a matter of local concern, but belongs to the state at large. Again, Michigan can define it this way if they want. If this were a matter of state law, that'd be fine, but we're not in state law, despite these citations. Under Michigan law, the State Board of Education has oversight authority over school districts and public schools within the state. But beneath this oversight and supervisory authority, the day-to-day administration of Michigan schools is usually entrusted to boards of local school districts and appointees. But usual is not always. Beyond general state authority with respect to public education, plaintiffs also allege the state has repeatedly intervened in day-to-day management of district schools and directly oversaw public education in Detroit from 1999 through the time in which this complaint was filed. So that's perfectly fine. Again, like the degree to which the state has control over various entities, localities is a matter of state law, right? We've discussed before that cities, school boards, anything within a anything within a state are creatures ultimately of the state. And so they can define it any way they want. And some are very independent and some are not. And so in Michigan, at least, there's some state level control and some local control. And there's a default presumption of local control, but the state can take over if things get bad enough. And, we saw that in the movie Lean on Me for whatever it was worth. That was the whole premise of that movie. The state was going to overtake from the locality, right? Because the district was so bad. So apparently Michigan's really like that and allows for that. And the school districts were taken over by the state in Detroit for various purposes for quite a long time because of failing schools. Okay. The plaintiff schools are 5 of the lowest performing schools in Detroit. The core of the complaint is conditions in the school are so bad due to the absence of qualified teachers, crumbling facilities, and insufficient materials that those schools fail to provide access to literacy. Plaintiffs sit in classrooms where not even the pretense of education takes place, in schools that are functionally incapable of delivering access to literacy. Because of this, plaintiffs attend school in name only, characterized by slum-like conditions and lacking the most basic guarantees of education that children elsewhere in Michigan and throughout the state take for granted. The whole lack of capacity to deliver literacy, functionally declaring no education at all. So we have schools that are in gross disrepair, as was referred to in the opinion, that there's schools without heating, without air conditioning. Schools get very, very hot, 90 degrees, 110 degrees in one case apparently, get very, very cold. They don't have qualified teachers. They don't have good books. So there's some schools that are really problematic in Detroit, right? And there's obviously schools that are really, really good in Michigan. I mean, there must be, right? Just by, it's a big state with a lot of people. So there's probably really, really great public schools in Michigan too, but not so much here. So there's a lot of really, really big problems here in this school district. Now, if this were a matter of equal protection of the law, if this were a matter of, that some students are being treated differently than others, that would be fine. Because these schools are so disrepair that I think there's some arguments to be made there. But to say there's a fundamental right to literacy is a little bit different than saying you're not treating us fairly. And they're saying fundamentally we have a right to literacy. So that's where this opinion is a bit breaking down. And we'll see that further on the opinion. According to the plaintiffs, the school conditions discussed above led to the abysmal educational outcomes, which further supports their claims schools cannot provide literacy. Yeah, they didn't have qualified teachers. They in some cases didn't have teachers with degrees, which doesn't necessarily mean they're not qualified, but they didn't have degrees anyway. They didn't have books. They didn't have textbooks. They didn't have heating. They didn't have cooling, crumbling schools, all kinds of problems. So yes, there was a lot of problems, and it makes sense that would lead to abysmal education. Okay, turning to the outcome data, the plaintiffs contend that while the outcomes are not dispositive of access, they remain relevant because the aggregate results shed light of opportunity to those afforded. Achievement data reveals that in schools, illiteracy is the norm. The proficiency rate in these plaintiff schools hover near zero in all subject areas. So apparently, they're hovering at close to zero in all the competency areas. So like 0% of school students are being able to perform up to like whatever the state standards are making of. So we've got some real problems in these schools. So I think that there's some real problems here that can be addressed. The question is the constitutional mechanism by which they're being addressed, and the way that this is being done. So the fact that the schools are in gross disrepair provides some real issues that need to be resolved. The question is the mechanism the court is doing it. On September the 13th, 2016, the plaintiffs filed their complaint in the Eastern District of Michigan. They alleged 3 causes of action: denial of fundamental right of access to literacy, violating both substantive due process and equal protection requirements of the 14th Amendment, which I didn't think is a thing that existed, but apparently is a thing that existed, according to this court at least. So, there's that. Violation of the Equal Protection Clause due to race-based discrimination, or just because of fact. I think that's a little bit more plausible. And claim for declaratory relief based on this and other causes of action. Turning to the merits, the defendants argue there's no fundamental right of access to literacy, calling it a mere proxy for education, which has long been rejected as a fundamental right. Yeah, there's much case law that says there's no fundamental right to an education. There's a lot of case law on that. And say, well, literacy is just a proxy for that. That's true. So like to say we're not giving you literacy is a problem. To say we're not giving you on equal terms, again, is different. But it's a different argument. Equal protection versus like the fundamental right to the thing. So it's different in that respect. Since there's no such right, any equal protection claim not based on protected class must be reviewed on a rational basis. And a review the defendants would argue shows the claims fail under Supreme Court prior education cases. Finally, defendants said that plaintiffs failed to plead a race-based equity claim because the conditions they complain of equally affect all students within same districts of the same race. Fair enough. So we're not under a protected class, so we need to show equal protection, and we need to show a rational basis to do it. So we need to show a rational reason to do it. Now, whether or not you can make that here is an interesting question, because the results are so disparate that you could make a pretty colorable argument, seems to me, that you can't even make rational basis. Rational basis is usually pretty easy. But, if you're having this level of problems, you can make a reasonable basis that this is just not rational. That something went wrong along the way. And you could order a remedy under that basis, which would be better. That there's some sort of problem here that needs some kind of redress. Under equal protection grounds, that makes sense. So even though the ultimate remedies might be the same, the logic of it matters and the reasons matter. Why? Because equal protection is well established. Rational basis review is well established. So we're using traditional legal mechanisms to reach a result. But here they want to create a different legal mechanism that's not known, and that's a problem. Because once you create a new legal mechanism, it can be used for any purpose. And then the question is, what are the limiting principles of this new thing you just created? There doesn't seem to be any. We'll get into that a little bit more. Turning to the first of these due process claims, the court notes that a case like this one could be argued on either positive rights or negative rights. And we've discussed that in a previous video on that too. Negative rights in this view are freedoms from government intervention or intrusion. Positive rights, by contrast, entitle affirmative obligation the states must afford its citizens. But the relief sought was exclusively positive in nature. You must give us something. And so the district court only considered the due process claim and whether access to literacy is fundamental rights. Now, on that point, knowing the court's reticence to find positive rights, even on unquestionably important aspects of life, the court held there's no such right. So, There is no fundamental right, and and there's no fundamental right to a lot of things. Like the government can't deprive you of life, liberty, or property, but it doesn't have to provide you those things in any respect, even if it's essential to your life. So, as a matter of constitutional law, the government doesn't have to give you things that will sustain life, liberty, or property. They just can't take anything away. So they're saying, yeah, that's the case law, and that's what it supports. $2 from Ricardo Ospinio, confused as to why this isn't in state court. I can only assume that the state law hasn't been as favorable to them as they want. Like they have a cause of action under their state constitution, right? Because they say it's a state level guarantee. But the state Supreme Court is the master of its state law. And so I would assume, I don't know, but I would assume that there have been tries in the state courts to get relief under the state constitution, and they've failed. That these guarantees have not been come out the way they want, so they can't get where they want to in state court. I'm just going to suppose that they have tried, and they can't get there. So they're going to federal court to try to create a federal cause of action because the state causes of action haven't worked. Now, just because the state causes of action don't work doesn't mean there's a federal cause of action. So, whether or not, Michigan should be reaching the decisions it is under its state law is neither here nor there as far as the federal government's concerned. The federal government's concerned about its guarantees and what it requires. So, if the state hasn't come through on its own constitution, that's a problem. That's a problem for the state to resolve. On appeal, both sides argue the district court erred. Plaintiffs say the court was wrong in finding there's no fundamental access right to literacy, and thus the district court should have dismissed the due process claim. They also argue the court should have considered a negative rights version of the due process theory, under which defendants violate their right to liberty by compelling them to attend schools in name only that fail to apply even minimum education. Okay, well, that's also a little bit more promising in terms of like traditional legal theory. So that you are compelling someone to attend school, so you're compelling them to do something. And when you compel someone to do something, that triggers a negative rights analysis, because the whole point of the Constitution is to prevent the government from doing stuff. So the government is compelling people to attend school, but they're not providing them school. So the due process, new negative process right makes sense as part of analysis, right? You are taking someone's away their liberty to do things in the guise of providing something, but you're not actually providing it, so you're making a due process violation under negative right. If the court had decided on those grounds, that would have been more promising. But they're coming with this affirmative right, which is, again, a different analysis. Faced now with the merits of this complaint, we first turn to the equal protection claim. The crux of the claim is defendants discriminate against plaintiffs by failing to provide access to literacy that they give to other students. Thus, even if there is no fundamental right to a basic minimum education, defendants, by choosing to provide basic education to some and not others, have still violated rights. This makes sense under equal protection. You have to treat people equally. And, you have not done that equally, so there might be a problem there. There's some debate over what level of scrutiny applies when a discrete group is denied access to education. Plaintiffs argue under Pyler, a form of heightened scrutiny applies in such cases. If the state is to deny a discrete group of innocent children free public education it offers to other children, that denial must be shown by something for furthers a substantial state interest. They also contend that even if heightened scrutiny does not apply, there can be no rational justification for denying adequate education and providing one to the other throughout the state. And that sort of makes sense given the totality of the environment that we saw. So what does the court have to say about that? But a review of the plaintiff's complaint shown they have not adequately pleaded equal protection, regardless of the scrutiny. That is because their complaint, while reflecting the awful conditions of their school, have not alleged any disparity in the state allocation of resources between their schools and the other. So they've shown a difference in the outcome, but they haven't shown a difference in the allocation. They haven't shown a difference in what was provided. And that's an essential element here. Nor do plaintiffs attack any specific decision or policy by defendants that treats their schools differently from others. So you haven't shown like there's a difference in policy or a difference in funding. You haven't shown where the state problem is. Thus, plaintiffs have not identified a government action or policy that discriminates, and the rest of the court was correct to dismiss their claim. So yeah, you showed the difference in the result, which is meaningful, but you haven't shown the difference in policy. You haven't shown the state has one policy or another, or different funding levels, so you haven't shown what the state is or is not doing with respect to this issue to show a disparate treatment. So there's a different outcome, but not necessarily a disparate treatment, and you haven't shown that. So they say, well, you haven't well pleaded it. So here I'd say, well, go back and make that argument. Go back and plead it out. Show what the state is or is not doing by funding levels, by allocation, by whatever it is they're doing, to show what the state is or is not doing, and show why that's not rational based on that, and go and flush that out. Now, I think that argument could be made, based on what we see. There does seem to be enough here to justify doing that kind of thing, but they haven't done it. And so the district court should have said, well, leave to amend, but not gone the next step of creating a new right. That was too far. They say, well, you can go perfect this, but, go perfect it and try again, rather than creating the new cause of action. When a state distributes benefits unequally, the distinctions it makes are subject to scrutiny under equal protection. At its core, the clause states that all persons similarly situated should be treated alike. Equal protection claims have to show two things. First, the defendants treat them differently to other similarly situated persons, and second, this difference in treatment is not supported by a strong enough interest. Much of the equal protection case law concerns the second part of the test, and specifically how strong the interest must be. On the one hand, if the policy does not concern a protected class, rational basis review is usually used, and a policy will be sustained if it's rationally related to a legitimate interest. The rational basis standard is extremely forgiving. The challenge action is presumed constitutional, and the burden is to negate every conceivable basis that might support it. Further, when social or economic legislation is issued, the Equal Protection Clause allows states wide latitude. So there's a lot of discretion here for the state under rational basis review, but you'd have to show the rationality to it. And you've got such disparity that I think you can make that plausible case. So it is broad, but it's not infinitely broad. And there might be a way to show that this is not rational. The outcomes are so disparate that if you can show disparity in the policies that don't make any sense, you might be able to get where you need to be. As noted above, as to state an equal protection claim, a plaintiff must both allege a difference in treatment, and the difference cannot be supported. But the current version fails to demonstrate this disparate treatment because it focuses on the school conditions and inadequately alleges the state policies or actions that cause those conditions. You focus on the result, schools are crumbling, but you fail to show the state policies or actions. What is the state doing or not doing to you versus everyone else? What is the difference that's causing this? Plaintiff's allegations thus fail to highlight any difference in the treatment that suggests the state's discriminating against them, and so have failed to adequately allege the government treated plaintiffs disparately as compared to similarly situated persons. Yeah, so there's a pleading defect here. You're not showing the difference in state policies. You're not showing the difference in state treatment. You're not showing how those policies manifest in one place or another. You're not making that chain of logic. You're simply going to the end result. And that's not fair. You need to show what the state is or is not doing to your school that is causing this problem. What is the state doing differently to you that is creating the problem that's resulting? And if you can show that, then you're on your way, even in a rational basis review. You have to show some rationality to it. So if you can show a disparate in treatment that between them, a different in policy, and you can show this horrible different outcome, your idea of making a rational basis argument is not trivially bad. So it's very deferential to the state. But you seem like you might have something that might work even under rational basis review, but you haven't shown that through. You haven't made the pleading, you haven't made the evidence. So if it were me, I'd be saying, no, go back and make that evidence, show what's there if it can be done, and show us why the state is doing this, and the state can come back with its reasons and show why those don't make sense. It seems like you could do that, but you haven't done that here. So you haven't made a cause of action. You might have. Leave to amend, sure. But the new cause of action doesn't really work. That's not to say it's impossible for the plaintiffs to allege an equal protection claim in this case. After all, Pyler said if the state is to deny a discrete group of innocent children the free publication it offers to other children residing within its borders, the denial must be justified by showing it furthers some substantial interest. It also implied that basic education is the standard at issue, and so a state action that results in provision of not even basic education could be subject to the same increased scrutiny. To state such a claim, plaintiff must identify the actions taken or policies implemented by defendants that treat the schools differently from others in the state and cause the disparities at issues. Since the current version of the statute complaint fails to do so, they should be dismissed. That makes sense. It's like the court is pointing out here that it is possible to make this argument. There is a case law that kind of supports it. We've seen a result that suggests this as possible, so you could do this and flush it out. You just haven't done it yet. You've not done enough to make this. Okay, so that makes sense. You haven't perfected this cause of action. Okay. The plaintiffs next argue the district court erred by considering their due process claim only through the lens of a fundamental right, since their complaint also raises a negative rights argument. Under this theory, plaintiffs argue a central element of their due process right, the right of freedom of movement and freedom of state custody, is restricted by the state's educational law, which forces them to attend school. While this right would be allowed if the state in return provided them with the adequate education, plaintiffs argue by detaining them at a school in name only, the state has failed to meet this burden, rendering the decision arbitrary and violating substantive due process. Now, Now, I do like this argument, actually. It's as a conceptual argument, right? I like this argument. It's like you have a fundamental right to freedom, you have a fundamental right to autonomy, right? And the state wants to deprive you of that, okay? But their entire rationale is we're going to provide you an education, and they've woefully failed in that. So they're essentially equivalent to, it's not a perfect analogy, but it's essentially equivalent to a taking without compensation under the Fifth Amendment, right? You're being deprived of something and not being provided anything in return. So there's that same kind of idea here. So this idea of the substantive due process right, my substantive due process right is not to the education. My substantive due process right is to the freedom. And you're not providing me the education, so you're violating the substantive due process right by taking away my freedom. I like that argument conceptually. It makes a lot of sense because, again, the Constitution, at least up until this point, protect negative rights, and it protects your right to not have government interference. And here they're interfering and not giving you anything for it. So I like that conceptually as an idea. The legal theory behind this claim appears to have strong support at law. It appears beyond debate that confining students to school that provides no education at all would be arbitrary, providing the common law understanding of due process tracking back to the Magna Carta. But as things presently stand, the district court was correct to dismiss the claim. The complaint does not provide notice that pursuing a claim based on the compulsory attendance and fails to allege sufficient facts. So here they're saying, well, there might be a cause of action here, but you didn't provide that in your pleading. You've come too late to the game. We've discussed this before in law. If you don't use it, you lose it, right? So these people did not make that sufficient claim. They didn't put them on notice that they were bringing that cause of action. It's too late in the day to give them notice to respond. And so the court is saying, look, there's an idea here that could have been played with. It wasn't well pled, but maybe someone else could try this. And so again, if it were up to me, I'd say, maybe leave to amend. So maybe we can go back to square one and leave to amend, or we can dismiss without prejudice, or there's other ways to deal with this. But go figure that out, because it's an interesting argument. It makes sense under a negative property right or negative liberty right. They're being deprived of something with nothing in turn. So that seems logical, but that's not the direction this court is going to go ultimately. The compulsory school attendance laws are a restraint of freedom of movement and thus implicate a core protection of due process. If a state required a group of people to sit in a building for several hours a day without any justification, the restraint would offend their right to liberty. And that makes total sense to me. And so if the compulsory school attendance is constitutional, it must be because the relevant interests outweigh that deprivation of liberty. Taken together, it's clear from these cases that, at least for compulsory education in general sense, which is the only type of schooling this complaint concerns, there's some level of education that justifies whether deprivation of liberty is caused by mandatory attendance or schooling requirement. But at the same time, forcing students to attend a school in which they're simply warehoused would run afoul of the due process clause. Yeah, I like that argument quite a lot. It makes quite a lot of sense. And it makes quite a lot of sense that, if you ask a group of random people to sit in a room with nothing, that would offend their liberty. And children have rights too. You're providing them nothing in exchange. So there might be an interest in the state educating people, but you're not actually doing that. So it offends the whole logic of it. So there's a substantive due process argument. Now, they didn't plead it well. They didn't raise the issue well. But I do like this conceptually. It makes a lot of sense. And so, if this was the rationale, then that would be okay. But, the court is pointing out, well, we can't decide on that rationale because it wasn't well pled. So we're going to create an affirmative right to get around that problem, which is not what I would do in this situation. While the plaintiff's negative right seems to have support in law and was argued in brief, it's noticeably absent from the complaint, brought too late in time. As with the equal protection claim, as this case is remanded, the plaintiffs could seek leave to amend and attempt to correct the deficiencies. But as their complaint stands, their allegation fails to provide notice, and accordingly, this claim is dismissed. So it's saying you could try to get leave to amend. You could represent this. It seems like you have something viable. Maybe we can do something there. That would have been fine. Well, let's press on. So having disposed with the preliminaries, having disposed with these legal theories that actually have support in the law as it exists, rather than doing that, we're going to create an entirely new third cause of action that doesn't exist anywhere, and we're creating for the first time. So that's super concerning because it's not defined. But let's see what the court has to say. Having addressed these two alternate claims, which are much more legally sound, we're left with the central issue in this appeal. whether the plaintiffs have a fundamental right to a basic minimum education, meaning one that provides access to literacy. Plaintiffs contend that access to literacy, as opposed to other educational advancements, is a gateway milestone, one that unlocks basic exercise of other fundamental rights, including the possibility of political participation. While the Supreme Court has repeatedly discussed the issue, it has never decided it. The question of whether such a right remains open today. After employing the reasoning of the Supreme Court cases and applying the court's substantive process framework, we recognize the court provides a fundamental right to a basic minimum education as a positive liberty interest. So the court here is saying there's a positive liberty interest because it's important. And that, for me, is where things break down. That's like, no, that's not going to work. I don't think that's right because, originalism, you look to the original understanding of things, and like there were schools originally, but, it wasn't, understood to be part of the essential liberty. So this argument, this argument is not in my projection long for this world. Either the Court of Appeals en banc or the Supreme Court will reverse this. I'm pretty positive because this doesn't make any sense. And creating a whole new fundamental right out of whole cloth is dangerous because it doesn't have any obvious limitations. If you have a right to literacy, why literacy in particular? And why not other basic skills? And what are the limitations? Why only literacy? Assuming you have a right to literacy, why only literacy? Why not basic math skills? Why not basic other skills? And maybe you say, well, you do, and then you're just expanding the ball ever forward. So it's like there's no limiting principle that's obvious. And, it creates some real concerns there. The Supreme Court has developed a two-pronged analysis it applies when determining an asserted right is fundamental. First, the Due Process Clause protects those rights and liberties which are objectively deeply rooted in this nation's history and tradition. The Supreme Court has applied a holistic approach to this history analysis, tracing evolution of asserted right through or even beyond the history of our country. Yeah, you go to common law. A few justices have instead embraced a narrower version, however, looking to whether the right in question would have been recognized as a protected interest at the time the 14th Amendment has adopted, which is what I would typically do. You look to whether it's adopted at the time. Now, you can obviously go backwards in time as far back as you want to establish that. But whatever the 14th Amendment meant, it meant the day it was written. How can it mean anything other than that? It must mean that what it was meant the day it was written. So, like, you want to look to history to figure out what that is, and I have no problem. But yeah, it means exactly that and nothing more. And so if it didn't mean that when the 14th Amendment was written, then it doesn't mean that now. The second prong of the inquiry looks to whether the asserted right is implicit in the concept of word liberty, such that neither liberty nor justice would exist if they were sacrificed. Beyond the general framework for assessing whether an asserted right is fundamental, the Supreme Court has also, in a series of cases, addressed the extent of constitutional rights with respect to state-provided education. Its educational jurisprudence takes several lessons. First, and this is pretty important, guys, so pay attention, the court has found there's no broad general right to education. So that's kind of dispositive for me. There's no right to education. Secondly, while there's no right to education, the court has specifically distinguished and left open whether a minimally adequate education is a fundamental right, because the court leaves open discussions if they're not relevant. So they always leave open things. Brown versus Board, of course, examined whether a racially segregated schools inherently violated due process. The court found they did, holding that in the field of public education, separate but equal has no place. During this equal protection discussion, the court took notice of critical importance of education. Quoting from that case, today, education is perhaps the most important function of state and local governments. Questionable, but okay. Compulsory school attendance laws and great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values and preparing him for professional training and helping him to adjust to his environment. In these days, it's doubtful any child may reasonably be expected to succeed in life if he is denied the opportunity to an education. Such an opportunity where the state has undertaken to provide it, that would be the key language there, so pay attention. Such an opportunity, highlight, where the state has undertaken to provide it, and highlight, is a right which must be made available on equal terms. Yeah. Ta-da, right? Okay. As argued by the parties, this passage can be read in two ways. On the one hand, if education is perhaps the most important function as required in the performance, how could it not be implicit? On the other hand, how could the state be compelled to provide education if it needs to be only equal to where the state has undertaken to provide it? Nearly 20 years after Brown, this question has returned to the Supreme Court. In San Antonio Independent School District versus Rodriguez, the plans challenged the constitutionality of Texas's public finance system, arguing the differences in funding across school denied equal protection of the law. Texas employed a dual approach to school finances, a system which led to both local school districts and states. But local funding rapidly outpaced what was provided by the state, meaning variations in property values led to substantial disparities in available funding. During litigation, Texas virtually conceded the system could not survive strict scrutiny, which would be really, really hard. Strict scrutiny is really, really hard, yeah. And so even if the uneven funding of school districts interfered with a fundamental constitutional right, it would have to be validated by the court. Which, it doesn't. It wouldn't survive strict scrutiny, no. In assessing whether the education was a fundamental right, the court began by referencing Brown, noting the country's historic dedication to public education, and agreeing the grave significance of education both to individual and society cannot be doubted. Despite this, the Supreme Court found education was not a fundamental right. Underline, okay? The Supreme Court found education is not a fundamental right. That's how you know this Sixth Circuit case is off the reservation. Saying that the undisputed importance of education will not alone cause this court to depart from the usual standard for reviewing a state's social and economic legislation. In denying the claims, the court specifically responded to the argument that education itself is a fundamental personal right because it's essential to the exercise of First Amendment and utilization of the right to vote. The court found this argument lacking, as plans believed to effectuate First Amendment and intelligent utilization of the ballot was tantamount to guaranteeing the most effective speech, a most informed choice, neither of which was protected by the Constitution. Quoting, the court's conclusion regarding this argument is especially notable. Even if it were conceded that some identifiable quantum of education is constitutionally protected, prerequisite to the exercise of either right, we'd have no indication the present level falls of expenditures provides short. So if it were conceded, for the sake of arguments, if it was provided, we're not there. Whatever merits appellant's arguments might have, its state financing system occasion an absolute denial of educational opportunities to any of its children. The argument provides no basis for finding interference with fundamental rights when only relative differences in spending levels are involved, and where, as is true in the present case, no change could be fairly made to the system that fails to provide each child with an opportunity to acquire the minimum basic skills for the enjoyment of right and full participation. Yeah, if you assumed it for the sake of argument, that would be true, but that's not what they said. With guidance, but no answers from the education cases above, which I'd argue there's some answers there about it not being a fundamental right, but okay, the court must assess whether basic minimum education, meaning one that plausibly provides access to literacy, why that is a fundamental right. Applying substitute process, we conclude the answer is yes. That's where I get way off the reservation. That's where I get way off the train. Because, no, it can't be. If there's a fundamental right to a basic education that includes literacy, what else does it include? If only literacy, why only literacy? And how much literacy, for that matter? What grade level of reading, for example, does it have to provide? What's the limitations there? Why not basic math skills or basic science skills? Are those also incorporated? What are the limitations of this basic right? The court doesn't seem to say. So there's some real problems there. It's not rooted in anything in the Constitution. The role of basic literacy education. What is basic literacy? What is basic literacy? I'm genuinely asking, what is basic literacy? What does that mean? Is within our constitutional framework suggests it's essential. More specifically, every meaningful interaction between a citizen and a state is predicated on a minimal level of literacy, meaning access to literacy is necessary. Further, the unique role of public education as a source for opportunities separate from the means of child's parents creates a heightened social burden to provide minimum education. Thus, the exclusion of child from a meaningful education by no fault of his own should be viewed suspect. In sum, the state's provision of basic minimum education has a long-standing presence in our history and tradition and is essential to our liberty. Under the Supreme Court's substitute process, this suggests it should be labeled as a fundamental right. No, that's just not going to work. This is not going to survive the light of day. It doesn't make any sense. It's not rooted in anything. It's not rooted in anything. It's not rooted in history. It's not rooted in an understanding of the constitutional terms. It doesn't make any sense. The defendants argue that access to literacy is not so fundamental to the ordered liberty and justice. To support this view, they note that at the time of the adoption of the U.S. Constitution, public education that went beyond rudimentary local cooperation was non-existent. Yeah, so it wasn't essential to liberty. It wasn't essential to liberty then, when it was adopted. According to the defense, since this country existed at that time, how could our society require state-provided education? Good question. The country existed, it didn't exist with this education, so, it can't be essential. Sufficient to say the practices of the 1700s cannot be a benchmark for what a democratic society requires. Why not? Why can't it be a benchmark for what a democratic society requires? Why not? If a democratic society was able to operate in 1700 with that, and it was a democratic society, then why can't it operate today with that? Why is it essential now and not then? Did people not have to interact with the government back then? Did people not have to understand things? Did people not have to read ballots? Did people not have to read, newspapers or periodicals? Did people not have to interact with other people and literacy was helpful? Why has it changed on a fundamental level? Why has it changed fundamentally? What has changed since then fundamentally? That would change this. It doesn't seem to flow to my mind. We hold, therefore, the right to a basic minimum education, one that can plausibly impart literacy. To what level, I don't know, is implicit in the concept of ordered liberty. Beyond the defendant's arguments with respect to due process, it's worth addressing two additional points. The first, raised in nearly every substantive due process, is the recognition of a new fundamental right is almost always improper as it compromises the will of the people by exchanging policy judgments of unelected judges for those of elected representatives. That's a really good argument, It's a really good argument, When you say something is fundamental in the Constitution, it takes things away from the ability of the people to vote on it and, express their political will. It takes things out of the range of choices. So that's a pretty damn good argument. It's taking things out of the democratic process because the democratic process can no longer tread on a particular level of ground. That is a pretty good argument. The second, which is more specifically accessible here, is that the Constitution is a charter of negative liberties, which it is, and so in most cases, only tells the government what it cannot do rather than what it must do. Yeah, pretty much. The oft-repeated argument raised by defendants and dissent is the 14th Amendment, which speaks in terms of deprival or denial, does not provide positive affirmative rights. Yeah, that's right, it doesn't. The Due Process Clause says what the government cannot do, not what it must do, and so recognition of obligation of the state to provide a basic minimum education would turn the language of the clause on its head. The Supreme Court itself has held the Due Process Clause generally confers no affirmative right to governmental aid, here will be the key words, even where such aid may be necessary to secure life, liberty, or property interests of which the government itself may not deprive the individual. That's pretty important. Though not explicitly described, the negative liberty framing is also embedded in several key decisions, which we, the Sixth Circuit, are going to ignore for some reason. For example, in Casey, the court portrayed its decision not as defending a realm of personal liberty which the government may not enter, and in Obergefell, the framed the substitute process as protecting citizens' choices, implicitly a negative right construction. But the court has recognized affirmative rights. Aside from specifically enumerated right incorporated in the 14th Amendment, such as the right to counsel, one affirmative right repeatedly endorsed by the court is the right to marry. I don't know exactly what right to marry implies in terms of that. I mean, you have a right to marry, but does the government have to provide you marriage? I'd have to get actually into the case law to be quite honest. I don't know. If the government is going to provide marriage, it can't do it on a discriminatory basis. That's true. But does the government actually have to provide affirmatively marriages? Can it say just that's an issue of state law, an issue of churches or a private agreement or whatever? Do they have to actually have marriages in the states if they want to? I honest to God don't know. So that's an issue, and yeah, so I don't quite know that that's the same category. And even if it is the same category, it would have been something that would have been established in common law. This right that pre-existed as part of this essential liberty. So also the right to marry doesn't really put much burden on the state because all you have to do is stamp the form basically. So it's not quite the same thing as provide me literacy, assuming that they do have to provide it to you in the first place. Since access to marriage was so uniformly provided by the states and expected as a people a matter of right, historically, I'm sure, it took on a fundamental character, even though the performance of marriage is an affirmative act. The same could be said for education. No, the parallels aren't there because the way the marriages were done, the way education was done are factually different. While the burden involved in performing a marriage is substantially less, that matters quite a bit too. The marriage cases at least show that does not categorically rule out the existence of positive rights. I don't know that I agree with that, but whatever. One additional point from the dissent is worth knowing. The dissent compares the right to a basic minimum education to a right to state-provided food, housing, or healthcare, and claims that deficiencies forecloses an affirmative right to these benefits. That's because, as our colleague says, it stands for the proposition a substantive due process does not regulate a state's failure to provide education regardless of context. And this is a pretty good argument. If the state has to provide you basic literacy, why doesn't it have to provide you basic food? Why doesn't it have to provide you basic housing? Why doesn't it have to provide you other basic things that are essential to life, liberty, and property? Why doesn't it have to provide a bare minimum of those things? Or does it? Are those part of the constitutional guarantees? Bare minimum basic food, bare minimum basic housing. The government has to provide you these things. Why is this only applied to education and not other essentials that are part of the essential port of life, liberty, and property? It's not immediately obvious. $5 from Ricardo Ospania. Right to marry for same-sex marriage is a negative right. The government can't prevent citizens from marrying on equal protection. That too. Yeah. But deficiencies, a case in which a child sued the state from failing to stop his father from abusing and seriously injuring him, concerned the state's failure to prevent harm caused by a private actor. Simply put, education is different. Its universal state education was nearly ubiquitous when adopted, is only grown then as to be gathered by the public. I don't know. I don't really understand the logic of that. There's a baseline level of essential education, but not a baseline level of essential food or housing or other essential things. And there's a baseline level of literacy. What level of literacy is unspoken, but not math or science or other things that might be essential. I mean, if understanding literacy is important in these times, why is not a basic comprehension of science important in these scientific and technological times? What are the parameters of this basic right of education? You've said literacy to what levels unsure, but why not other stuff? I don't know. Importantly, the right defined in this opinion is narrow in scope. Is it, though? It does not guarantee an education of the quality that most have come to expect in rights today. But why doesn't it? Why doesn't it? What is the limiting principle? See, that's the thing that I worry about. What is the limiting principle? Why doesn't it do those things? Why doesn't it go that far? You say it goes this far and not farther, but why? You say the right defined here is narrow, but why is it defined narrowly? Why is it defined narrowly? What's the basis for defining it narrowly? What are you pinning this on? Why shouldn't a future court broaden it out? What are the limiting principles that say, well, we think this is also essential, we think that's also essential? You're not explaining the basis for what's going to prevent this from growing. Rather, the right only guarantees the right to an education needed to provide access to skills that are essential for the basic exercise of other fundamental rights and liberties, most importantly, participation. Well, what would that be? Access to skills that are essential for basic exercise. Like what? Math skills, science skills, art appreciation skills? To what level of competence? To what degree? What are the limiting principles? As described by the plaintiff, this amounts to education sufficient to provide education to a foundational level of literacy. What's foundational? The degree of comprehension needed for participation in our democracy. Oh, so foundation is the degree of comprehension needed for participation. Well, what's that? Full, complete participation? All the participation? Which then I wonder, do I have that right level? Do I even have that level of literacy? Because I don't understand everything, but, I mean, what are the limiting principles here? There aren't any. It's unmoored. So it's a really interesting case, and there's no way this is going to survive. While the precise contours of the infrastructure must be defined through the course of further litigation and examination of evidence, yeah, that's good news. It would seem to include at least three basic components: facilities, teaching, and educational material books. What kind of facilities? What kind of teaching? What kind of educational materials? Yeah. Our dissenting colleague criticizes this approach, implying our holding today will create a freewheeling right. It is freewheeling. There's nothing mooring it. Why isn't it freewheeling? Why is it limited this way? Why this? Why literacy? To what level? Why that level? What are the limiting principles? Why that? Why not basic levels of food? Why not basic levels of what other essential things? What are the limiting principles here? It is freewheeling. It's unmoored. Now, allow federal judges to micromanage the work of local school boards. While we do not believe this is a fair description of the limited right embraced in our opinion, it may not be a fair description of the limited right described in this opinion, but why is this opinion the end of the game? It's not said, which promises only an education sufficient to provide basic access to literacy, whatever that might mean. So that is our end of this coverage of the Court of Appeals case of Gary B. and others versus the government of Michigan. In this case, we learned that some school children are provided with truly horrible care in their schools, and their schools are truly horrible. We learned that there might be some theories that might help them. They might have a theory of equal protection. They might have a substantive due process issues. Unfortunately, neither of those issues were particularly well pleaded out, particularly well justified, particularly well specified. So the Court of Appeals could have sent it back for those things to be fleshed out and expanded better to make the cases better. But what they did instead was they created a brand new fundamental right. The fundamental right to basic literacy, whatever that might be, and just that, but not basic rights to math or science for no particular reason, and not basic rights to food or shelter or water or other essential things for no particular reason. And they say, but the dissent says it's freewheeling and unmoored. I'm like, yeah, it is freewheeling and unmoored. It doesn't make any sense. It doesn't make any sense because there's nothing tying it to anything. That there's no limiting principle that I can see, even contemplated in this position that I can see. The main opinion says that our decision is relatively minor, but why here and not for why this far and no farther? It doesn't seem to provide. There's nothing limiting this that I can see. And so, they've opened a door to something that doesn't seem to have any obvious limitations. Whereas the other theories that were offered, equal protection, substantive process, have some limitations. That because they're understood. So I object to this decision both on legal grounds and pragmatic grounds. I object to it legally because it's not legally moored. I object to it practically because it's unmoored. And it would just lead to endless stuff. So I think the odds are pretty decent that this was going to be reversed. So en banc by 6th Circuit Court of Appeals, U.S. Supreme Court, I don't think it's going to be long for this world. I just don't think the logic of it makes sense. I don't even really see this as necessarily a 5-4 decision by the U.S. Supreme Court. I think you're going to get some, I see it more like maybe a 7-2 if it gets to the Supreme Court. But if we ever get that far, we'll certainly have an oral react to it. And that's our end of the coverage for this case for now. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.